Power of attorney is a very specific estate planning document. In a power of attorney, it allows you to identify an agent to be able to make financial decisions for you on your behalf if you are unable to do so. A financial power of attorney is just for financial purposes. It has nothing to do with healthcare wishes. And this is really where the distinction comes in and a lot of misconception when it comes to estate planning. A power of attorney is made up of part of an estate plan. It is not an entire estate plan. A comprehensive estate plan includes a will, a power of attorney, a trust, advanced healthcare directive, HIPAA authorization, and many other documents. So a power of attorney, while it is very important, is not the only document that is necessary. However, a power of attorney is a document that specifically allows your agent to be able to act for you if you are unable to do so. Maybe there's a car accident, maybe you have a stroke, maybe you have Alzheimer's or Parkinson's or something where you don't have the mental capacity to be able to act on your behalf. This is where the power of attorney document will come in. One of the biggest misconceptions I hear people say when it comes to power of attorneys is that a power of attorney will help after somebody actually passes away, and this is not true. A power of attorney is only valid while someone is alive. It allows you to act on their behalf, which means a power of attorney only comes into play when somebody is incapacitated, not when they have passed away. There are different types of power of attorneys when you are looking at putting your plan in place. In California, we have the ability to do what's called a springing power of attorney, which means if you are healthy and you have no reason to put somebody in control of your finances at this point, you can make it spring into effect upon your incapacity. So as of right now, they wouldn't have any control over being able to do things for you, but it would only spring into effect upon that incapacitating event. When you have a financial power of attorney, again, where you identify this agent to be able to make financial decisions on your behalf, you are then choosing who you want in this role. Without having a power of attorney document, if you are in a situation where somebody needs to get access to your bank account, maybe they need to sell your home to be able to put you in an assisted living facility, then at this point, without having a power of attorney document, they might have to go to court and get what we call a conservatorship. A conservatorship can cost anywhere from $5,000 to $10,000. And at that point, you have a judge making a decision on who they are going to choose to be the conservator, and you have no choice because at this point, you wouldn't have capacity to be able to make this decision. It is always best to get this document done now and to work with a professional. I had somebody that called in and they did a plan online. They did a DIY power of attorney. And unfortunately, the document that they did was not a durable power of attorney. And in this exact moment that they needed it, what had happened is there had been some life event that had happened that had made the power of attorney void. And so it was almost as if it had never existed. And in that exact moment that they were in an emergency and in a crisis situation, the power of attorney that they thought was going to work did not. It's always best to work with an estate planning professional to make sure that whatever your wishes are legally documented and the documents are done correctly in case there is an emergency.